The next, excuse me, the next case on the docket is McCarthy versus Adams.
Good morning, Your Honors. For the record, I'm Shelby Lemmel of Masters Law Group here on behalf of the appellant, Alan Adams. If I could please reserve 3 minutes. Thank you. Your Honors, as much as this is a family case, it's a contract case. And I don't have to tell you that contracts are reviewed at de novo and that your process begins with the plain language of the contract. And so that's where I will begin as well. And I'd like to focus on the provision dealing with Navazon, the business entity. What that provision states is a wish to create a joint ownership interest in the business after marriage. Now, those words have meaning, and particularly because they are different than other words used in the contract. This provision does not use ownership interest, as is used repeatedly elsewhere in the contract, or excuse me, does not use joint ownership. It uses interest, and it does not use upon marriage, it uses after marriage. So taking these 3 terms together, what does that provision mean? Its plain language is the expression of a desire at some undefined point in the future, but after marriage, to create some interest in the company that is also undefined.
Then why even include that paragraph? I mean, what meaning does it have in this prenuptial?
The meaning is that the purpose of a prenuptial agreement is to put everyone's financial cards on the table.
So why isn't this listed as separate property then?
Because my client is doing something more than expressing a desire to maintain it exclusively as a separate property. He's expressing a desire to possibly in the future create a joint ownership interest. He's not saying, I just want this to be my separate property forever. He's saying this is something else. It's different. It's different than the other assets we've listed. My desire is that at some point you might jointly own a piece of this. And what might that look like? It might look like coming to work for the company and leaving the job at the Gates Foundation, taking employment with Navazon. She states in the briefing that she's participating in the business and supporting him, and they're talking about it, and she's helping prepare him for seminars. Well, maybe that's more in the future. And what he's saying is that is my desire, that in the future it will be more. We don't know what her desire is. We can guess because the optimal time for this interest to have been defined and recognized would have been when Navazon was incorporated in 2019. And there are at that point 2 additional owners who are issued stock. But she doesn't step forward in 2019 and say, let's define my interest. What is it? And I want my stock now, because now is the time that I want to take my interest in the company.
Well, isn't there a difference between, let's say, ownership on paper, the corporate ownership, whether she becomes a partner or a shareholder, versus how this is characterized as community versus separate property? Which is what's at stake here is how the trial court ultimately is characterizing this property.
I think that's correct, and the court characterizes it as community property, of course. There is nothing in this agreement that creates community property. This provision doesn't talk about community property, and community property, as this court knows, is a present, undivided 50-50 ownership of the total. This is not a present interest. It is an interest that is anticipated at some undefined point in the future. It's not a present interest. It is not a 50-50 interest. So by its nature, this provision is not talking about community property. That's why the trial court's interpretation is clearly flawed. It's why the interpretation proffered by Ms. McCarthy is clearly flawed. This is not community property. Creating community property in a prenuptial agreement is pretty simple. I am gifting my property to the community. I am taking my property and converting it from separate to community. That did not happen. So there is no reasonable interpretation of this agreement that it created community property in this asset. The other arguments proffered by Ms. McCarthy is that this provision is self-executing. That's impossible. She's clear about what her argument is. She is clear that the argument is upon their marriage is the same thing as after marriage. Those different terms do not mean the same thing. She is clear that her argument is ownership is the same thing as ownership interest. That's not the same thing. Joint ownership, when you're talking about 2 married people, logically concludes when it is not defined to be anything else. We own it together. We jointly own it, 50-50, community property. When you're talking about an interest in a corporation, you're not necessarily talking about 50%. It could have been 2%. My client owns the business. He's not giving away half of his company in a prenuptial agreement. And there is no logical interpretation of this agreement that that is what he was doing. And so we have asked the court also that if you agree with us that this provision does not create community property, which it plainly doesn't on the plain language of the contract, if it's not conveying any present interest in the company, then there's no logical interpretation of the agreement that my client was nonetheless giving her half of 2 business bank accounts. Now, we've acknowledged in the briefing, of course, the language with the Navazon bank accounts is different. That language does say joint ownership upon marriage. And frankly, Your Honors, I've been candid in the briefing, that is poor drafting. It should not have said that.
It wasn't that the primary argument below that this was, or the only argument below that this was an unfair prenuptial or inequitable prenuptial? I mean, wasn't it below that a challenge to the prenuptial itself?
He challenged the prenuptial agreement. He also made these exact same interpretation arguments, and I would ask you to look at Clerk's Papers 975 and 618 to 22. And it's common, as this court knows, for parties to argue both that a prenuptial agreement is unenforceable, but alternatively about what the agreement says, what it means. And it is particularly at Clerk's Papers 975, my client, representing himself to his credit, made exactly these arguments. After marriage does not mean upon marriage. The undefined interest is not the same thing as a 50%. He made these exact same arguments, Your Honor. And so returning quickly to the bank accounts, my client entering a prenuptial agreement, which is an individual person looking at an agreement in contemplation of their marriage, is not acting as the president of a corporation intending to give a non-member, non-owner half of the corporation's bank accounts. He doesn't have the authority to do that, and that would be a truly absurd interpretation of this contract. I'll reserve the rest of my time for rebuttal. Thank you.
May it please the court, Rory Cosgrove on behalf of respondent Erin McCarthy. I'm principally going to be focusing on how the parties objectively intended to characterize Navazon Consulting LLC under their prenuptial agreement, because the prenuptial agreement controls. Before I turn to that issue, I want to make clear what exactly Alan Adams is arguing. His argument is he is isolating at the extreme margins one preposition in one isolated provision involving the most valuable asset that the parties have, disregarding hundreds of other provisions and thousands of other words to argue that this asset is separate property. And he's also, by extension, arguing that it remains separate property because the parties created a legally unenforceable provision. That interpretation is unreasonable, that interpretation is absurd, and that would render meaningless the Navazon provision in the contract. And we know that courts must adopt reasonable arguments, they must try to give effect to all terms in the contract, and they should not render provisions meaningless.
Can we agree, though, that the way this prenuptial is written, the assets are set out in different categories. So there's a category for real property, a category for bank accounts, retirement accounts. Business Navazon is its own category. Mm-hmm. So we're reading the Business Avicon, and the words in that provision are different from every other provision. It's not just a joint ownership, it's a joint ownership interest after marriage. And that's different from every other provision.
Well, we have to look at that provision in the context of the rest of the agreement, not in isolation, in context. But it means the same when you look at how the parties objectively intended to characterize all their assets.
Why did they use the same language?
Well, what you're driving at, Your Honor, is that what Alan asked this court to do is elevate the canon of construction that when words are used differently in a contract, they must mean different things. But you can't elevate that canon of construction over other canons where, again, the courts must adopt a reasonable interpretation. They must try to give effect to all legal provisions. And under the trial court's interpretation of this agreement, and the same one that Erin McCarthy has always advanced. You can give effect to all provisions in this contract when the objective intent from reading every single provision in this contract is that the parties intended for Navazon to become community property once they married. And let me explain, Your Honor, if I may. To ascertain what the parties intended in a contract, you have to understand what the objective of the contract was. We know that the entire purpose of this prenuptial agreement was to characterize the nature and extent of the parties' assets and to determine whether that asset remains as separate property or if that asset was transformed into community property. I turn to the recitals. Recitals paragraph 2 and recitals paragraph 5, and this is important. Recital in paragraph 2 reflects an objective intent that the parties would fix and determine all their rights and all their property. Fix and determine, that means set in stone at a point in time once the parties got married, not subject to some indeterminate time in the future. They're fixing the rights and all property that they then own or later acquire. We also know that the purpose of this contract was to characterize all their assets. We turn to paragraph 5. The objective intent under the plain meaning of those words is that the parties intended to define the parties' property as either separate or community property. The parties carried out this intent in characterizing all their assets by disclosing all of their property in the 2 schedules attached to the prenuptial agreement. And in those schedules, consistent with their objective intent to characterize all their property, the parties intended for each asset either one, as the parties use the phrase, to retain their separate property or to transform that property into community property. The parties consistently and unambiguously use the phrase wishes to, as the trial court correctly concluded, throughout the schedule to indicate an intent of what the parties intended to do. So, for instance, for property, and Alan doesn't dispute this, for property that the parties intended to retain as separate property, they use the phrase wishes to retain separate ownership upon marriage. And so once the contract was signed and once the parties got married, that property automatically remained separate property. And then when you turn to...
Can we pause there just for a second? So your opposing counsel gave her definition of wishes to in the context of the company. What is your definition of wishes to then? And what's that based on? And is there any authority? I mean, there are a lot of cases that define a lot of terms out there under contracts, right? And then we turn to them and we say, that's helpful. They defined it that way. Do you have any authority for your definition?
Well, the authority for the definition, Your Honor, is that wishes to is used consistently and unambiguously for all of the assets that the parties identified.
What does it mean, first of all?
It means intends. Okay. And the reason it means intends is for the assets that the parties identified where they intended to transform an asset into community property. For example, Navazon's Chase bank accounts. They use the phrase wishes to create joint ownership in this property upon marriage. The phrase wishes to has the same meaning throughout the agreement. And so it's no different in the Navazon Consulting LLC provision. It means the same thing. And so for the assets that the parties intended to transform into community property, they use the phrase wishes to create joint ownership of this asset upon marriage. There's no distinction between the phrase joint ownership and joint ownership interest. And certainly for Navazon, it's important to go back in time when the parties signed this contract. The court is interpreting the contract and its meaning at the time the parties signed it. At that time, Navazon was Allen. Allen was Navazon. It was a single-member LLC. He was the sole manager. He was the sole employee. He had every right to transform that asset into community property. And it makes no difference that 2 years down the line, he decides to incorporate it. It makes no difference because at that point, then the stock becomes community property. And what's important is you look at RCW 2616-030. And what that statute says is that it entitles a spouse to manage and control community property. And then in Dean v. Lehman, the Supreme Court, citing the line of cases establishing that a spouse's community property interest does not dissipate simply because he or she is not in a position to exercise control over the property. There's a distinction between the LLC, in that case, Allen was the sole member, and the membership interest. The membership interest is what became community property under this agreement. And it frankly makes no sense that, as Alan concedes, the parties would intend to transmute Navazon's Chase bank accounts into community property once they married, but not the LLC itself. And again, we're talking about looking at all of these provisions in context, not as Alan urges this court to do, looking at one provision in isolation, focusing on one preposition. And let's not forget, this phrase after marriage is not the only time in the contract the parties used that phrase. They used it in two other places. One in recital 6, and also at the end of the property schedule for Alan. And I think it's important to juxtapose what the parties, when they used that phrase there, when they used it in the Navazon provision. And in paragraph 6, and this is the provision discussing Alan's lawsuit against the government over his military service. It says, if Alan Adams prevails and is awarded a favorable judgment, said judgment amount shall remain his separate property after marriage unless he affirmatively converts the judgment into a community property asset. By contrast, in the Navazon Consulting LLC provision, there's no such words that follow after marriage. And again, that indicates an objective intent when you look at the rest of the contract as a whole, that when the purpose of the contract is to characterize all the parties' assets, that when the parties have used after marriage, they said unless he affirmatively converts that judgment into community assets. No such language follows this.
But the difference in paragraph 6 is it's a contingent, something that hasn't occurred yet, if he prevails in litigation. So, I mean, that's a completely different thing than he already has Navazon.
Well, the point I'm making, Your Honor, is that this provision that Alan has focused on and isolated and disregarding the rest of the provisions is that it doesn't say that husband-to-be wishes to create joint ownership interest with wife in Navazon after marriage unless Erin never comes to work for Navazon, unless Alan decides never to issue stock or a membership interest to Navazon. This provision under the recitals, when looking at the entire contract, was self-executing. The rest of the assets were, and there's no material or functional distinction when it comes to Navazon itself.
Thank you,
I ask the
counsel.
court to affirm. Thank you.
I'm a little taken aback by the attempt to recharacterize my argument as one ignoring the entire agreement but the provision having to do with Navazon, the business. Because the reason that provision means something is precisely because the language in it is different than the language in the rest of the contract. I am asking you to look at the entire contract and notice that a joint ownership interest is different than joint ownership, as you pointed out, Judge Mann, that is used every other time we're talking about property in this contract. I am asking you to look at the context and notice that after marriage is different than upon their marriage. So we are talking about context. We are talking about the entire contract. We are not attempting to isolate a provision. We are doing quite the opposite. I am not the party before this court asking you to ignore what portions of this contract mean. I am not the party before this court asking you to rewrite the contract. What you would have to do to interpret this provision to create community property would be to ignore after marriage, because community property is a present interest. It would be to ignore interest, which is undefined and could be 2%, 10%, 20%, or 50%, because community property is a 50-50 interest. So you would be defining undefined terms in the contract to mean something that the parties did not agree to, striking out the word interest, and ignoring the word after. So we are not the party that is asking you to ignore portions of this contract. If Ms. McCarthy thought that what she got was a present ownership interest in Navazon when this contract was entered, why not step forward when it incorporates and say, let's define what that number is? Or why not work for the company? Or why not say, I want stock, or I want my name on the corporate documents? We know she didn't want her name associated with the corporate debts because that was made clear in the trial court, that she wanted nothing to do with the business facing significant contingent liabilities. Because taking an ownership interest in a company isn't just taking its profits, it's being on hook for the debts too. and she didn't want any interest in that. So her actions are inconsistent with the argument you're hearing today, that she thought she had a present ownership
Let's
interest.
jump ahead, though. If you're right, and this has to go back to the trial court still has to look at all of the property, including the separate property, and still make a division, right?
No, because the prenuptial agreement controls. The parties agree to that, and the separate property is not before the court. So the separate property, each party clearly says in the agreement, that's out of, they can't touch it. What would be before the trial court is the community property only. I'll ask you to reverse. Thank you.